Okay, I think we can start. So welcome everyone to this ITechLaw webinar on copyright policy development for AI training, an international issue. I am Mariana Ferreira from Portugal, and I am joined here by an amazing panel of speakers from different jurisdictions. We have Ricardo Gomes Barreda from Spain. We have Larissa Leonardo from Brazil, Chloe Taylor from the UK, James Gatto from the US, and Takafumi Ochiai from Japan. We are all IP lawyers and IP practitioners, members of the ITechLaw IP committee, led by Jeremy Morton, also here, who have been diving into the complex issues of AI and its impact on intellectual property rights and rights holders. You can find more information about the speakers at the ITechLaw website. In this webinar, we will address one of the current hot topics of AI and IP, use of third-party content to train AI models. Our discussion will be based on the assumption that third-party content is protected by intellectual property, notably by copyright or author's rights, depending on where you are based. We know that this is not always the case, but for the sake of this conversation, we will assume that content is indeed protected. We have prepared this webinar as a set of Q&A on this topic, where we will hear about the perspective of our experts from Spain, representing the EU, Brazil, UK, US, and Japan. We hope to have time for an additional Q&A from the audience at the end, so I ask that you submit your questions in the chat while we discuss this topic, and if we can, we will get to that later in the webinar. So let's dive in. So to start off, let's discuss what is the state of the art regarding use of third-party content to train AI models. And let's start with you, Jeremy.
Great, Mariana, thank you so much. I wanted to mention, so in Europe, we do have a specific legislation, as I'm pretty sure most of you will be aware. Basically, since the 2019 directive on copyright in the digital single market, we have the so-called text and data mining exemption, which is basically Articles 3 and 4 of said directive. It was transposed in all EU member states by 2021. That was when it was the deadline. And basically, text and data mining is defined as any automated analytical technique aimed at analyze text and data in digital form in order to generate information, which includes, but is not limited to, patterns, trends, and correlations. I'm mentioning the specific definition because there is a first interesting question and discussion as to whether training of AI, including generative AI, is or not text and data mining. It's a very interesting question, and there are very different opinions online, which can be found online. To be honest, right now it looks like the current consensus is that text and data mining is at least part of the AI training process. So I would say that, and the two cases which have taken place in the EU already, seem to have tackled that. So yeah, I guess that's the most important thing in the EU. In the EU and in Spain, we'll be mentioning later that we've also had a proposed regulation aiming to get CMOs, so collective management organizations, to be the ones to provide licenses for text and data mining.
And Chloe, what about the UK?
So, unlike the EU, we have no specific legislation relating to the training of AI models at the moment, or at least that really covers it in the same way. Rather, we would tend to understand this application of copyright law through our traditional copyright legislation, so the Copyright Designs and Patents Act from 1988. That said, something I'll be returning to throughout our webinar is that the government here did consult on potential changes to copyright law arising from kind of AI use cases. And that happened end of last year, beginning of this year. And their proposal, did include a recommendation for a revised text and data mining exception. As you'll see, it remains a proposal in the ether. Yeah.
And Jim, what about the US?
Hi. In the US, there's no specific legislation that deals with this, with AI specifically. the primary law that's going to govern here is the general copyright law, which says basically copying without authorization is infringement unless an exception applies. And the main exception is what's referred to as fair use in the US. Fair use is a four-factor test that looks at kind of a balancing of the four factors to see whether a use is a fair use or one that it's not. There were two very significant decisions just in the last week on fair use. And in short, in both cases, the AI tool company was found that the training they did was fair use, but there's significant cautions on both of those decisions. It's very fact specific, so it's not a per se rule that training on AI content is fair use. I'm sure we will see different decisions. We also saw in these two cases, the courts, while they came to similar conclusions, they came to it for very different reasons. So even the two courts didn't agree on the basis. And so I think what we're going to see over time is an evolution of case law that interprets fair use under different fact scenarios, and that will govern what is and what is not fair use in the US.
And let's go to Japan, Takafumi-san.
Yeah, thank you. So Japan has big exemption clause about using copyright content for or training artificial intelligence, not limited to artificial intelligence, so such as type of statistical use. Such use can be protected by such exemption clause. This was amended in 2018. So there are some time from the set into effect. We are using these exemption articles in order to train artificial intelligence very broadly.
And finally, what about Brazil, Larissa?
Hello, everyone. In Brazil, we rely right now on our Copyright Act, which is from '98 also, and there's no legislation acted so far on AI, but we do have a proposed bill of law that has been discussed by the Brazilian House of Representatives. It's very similar to the EU Act, so more risk approached, and there is a specific discussion on copyright protection there. As well as obtention of authorization for the proper use or applying the TDM exception. And we will address that during the questions of Mariana, but I think that's kind of the scenario here. We have a Copyright Act and we're leading towards a discussion on AI specifically to try to regulate it.
Okay, so it appears that except for Japan, everyone else is seeking, all other jurisdictions are seeking the answers in copyright and IP law. And so let's discuss what is the actual general perception of legality regarding use of third-party content to train AI models in each of our jurisdictions represented here. And I'll start again with you, Ricardo.
Great, Mariana. So I would actually say that the general perception is that it is legal to use third-party content to train AI models, basically because of the TDM exemption. And I'm sure some people could actually disagree with that, basically because it also, at the end of the day, completely depends on, on the facts of the specific case at the end. As you mentioned, we're assuming for the discussion that the content used is protected by copyright. So that would mean that an authorization would be needed. However, at the same time, we've got the TDM exemption, the text and data mining exemption, which basically means that no authorization would be needed. But at the same time, the TDM exception includes several requirements, such as the opt-out, which we will discuss in a minute, which basically might entail that an authorization is still needed. So basically, completely depends on the case. And I guess that's the complexity of the TDM exception. It kind of sets the ground rules of how things, work, but at the same time enables the relevant stakeholders to make their own decisions,
And what is the legal perception of use of content in the UK, Chloe?
Yeah, so I think the general perception here is that that kind of unauthorized use would be de facto an infringing act under the relevant legislation that already exists. And I think we kind of see that come up in the public responses that happen to the government consultation for this potential new law, as well as some interventions we've had from quite high-profile creative people in terms of the government's attempts to actually get those new laws through Parliament. So I thought there was an illustrative quote from Sir Elton John, for example. So he got involved back in May when, as I say, government was trying to get through this new law, and he gave a speech both to the House of Lords, but also a bunch of interviews. And he said of this proposed change to have a kind of text and data mining exception, that he felt that the government was on course to rob young people of their legacy and their income, and that in his view, it was a criminal offence and that government are being absolute losers, and he's very angry about it. And I think that, you know, summarizes the feelings of a lot of people in the creative industries, which is a big and important sector in the UK, and really contrasts with some of those in government who are much keener to try and liberalize things in favor of the AI companies. But yeah, it's a mixed picture right now.
Yes, I can believe that. And what about the general perception in the US, Jim?
Yeah, so I think there's very strongly held and diametrically opposed views on the part of the creators. They think this is not just infringement, but it's going to destroy their livelihoods. So they feel very passionate that this should not be deemed fair use and it should not be permitted. On the other hand, the tech companies primarily argue that this is a very transformative use. It's a tool that is not designed just to copy. It's designed to create new content, and with appropriate safeguards, like making sure there's certain techniques that can be used to minimize the likelihood that any output actually copies any substantial portion of content that was used to train the model. That with that type of approach, that the use should be considered fair use and not infringement.
So again, we go to the factual approach and not a more general solution, let's say.
There's not going to be a single per se rule in the US, in my opinion.
And what about Japan, Takafumi-san? What is the
Yes.
general perception?
Yeah, so in Japan, so exemption codes can be applied to use case or to the extent of the necessary when the purpose is not the enjoyment of the ideas or feelings of the copyrighted work. So of course, so human beings cannot enjoy such works, and also not provide third party for enjoyment of such work. However, so in many of the such learning process can be covered by exemption codes, including type of reproduction of the AI, not AI, so copyright work, and also use such work for training process of artificial intelligence. So this is so very useful for developing artificial intelligence.
So what it means, if I understand you correctly, is that if it's for the development of society and for science purposes, it's go ahead, very liberal. But if it's for an enjoyment of artistic works, then there are some concerns.
Yeah. So there is so some argument about so what you mentioned. But generally, so developers are using only training process of the so by machine. So this is so main protection scope of such exemption clause.
Yes. And Larissa, what about Brazil? What is the general perception of use of third-party content in Brazil?
I think it would be fair to state that the tendency here is the use being illegal if there's no authorization, since we are relying on the Copyright Act still. But also when we look into the AI Bill of Law that is under discussion, we do have one's position about publishing an online list of which content was used to train the AI, for example, which can be very tricky, right? Our TDM exception is for research and not commercial use, different from the U where you have the possibility, but you can opt out. Here it's more towards the UK. And on the other hand, we know there is a lobby of the big companies during this discussion to amend one of the articles of the Brazilian Copyright Act, and this is to increase the exceptions to the protection of copyrights, author rights, but the Brazilian law in general, it aims to protect the author, not the copy. So this eventual exception, the increase of exceptions, would guarantee a leverage for tech companies. Nothing is written down. What we do have now is the AI Bill of Law that can be a little more conservative. So that's why we imagine the tendency here is more towards the copyright protection. And usually the case law is also important to define the outline of these matters. Right now, we just had a major ruling on the liability of platforms in the Supreme Court, for example, determining the removal of content regarding sensitive topics. This changes a little bit the game here, but there is nothing relevant on training AI yet. So we are kind of waiting to see how it goes, both court decisions and the final text of the AI Bill of Law.
So it is very interesting to see that the most conservative approaches appear to come from the UK and Brazil, and the liberal ones from EU, although we do have the opt-out, and from Japan. It's in this regard, it's very strange to see the EU side with the liberal approach. And we have the US approach that is, well, often based on solutions that will be granted by case law in the future. It's a litigious jurisdiction, as we know, and we expect to hear a lot from the court decisions from the US soon. So we were talking about the TDM exception. Most of you have already referred to this. This solution derives from the legislation surrounding the Digital Single Market Directive of 2019. So it's the state of the law in Europe. Ricardo, can you please elaborate how this applies to AI and AI training of AI models, please?
Yeah, sure, Mariana. I mean, I guess most of you are already familiar with this, but just in case, I'm going to dedicate a minute to explain it. So basically, the so-called TDM exception actually corresponds to two different exceptions. You have the one in Article 3 of the directive, which basically covers or legitimizes the use of works for text and data mining for the purposes of scientific research. And the second one is the exception or limitation in Article 4, which covers TDM for any other purposes, including commercial purposes. The important thing there is that aside from their purpose, the main difference is that the second one, the exception in Article 4, provides an opt-out mechanism, meaning basically that the rights holders may expressly reserve the right to use his or her works for text and data mining. So, I mean, at the end of the day, I would say, Mariana, I'm not really sure if it's a liberal solution. It probably is, but at the same time, you know, it is a liberal solution, I would say, because in the absence of a statement from the rights holder, it actually enables text and data mining, but at the same time, it's kind of giving them the chance to be able to state what they want whether or not they want their works to be used for text and data mining. I guess that's why the EU considered this to be a fair solution. In fact, if you read the whereas of the directive, of the 2019 directive, basically that seems to be the idea. Users of text and data mining can have legal certainty as to what can be done or what are the ground rules. And at the same time, rights holders have the alternative to opt out and thus are able to license the use of their works, you know. There's also a big question there. The big question which, you know, it's being discussed is how such opt-out must be conducted. It obviously also depends on the case. The DSM directive states a few examples, tells you that machine readable means would be an appropriate manner in the case of content made publicly available, but also states that terms and conditions of a website or a service could also be used. Here, you probably all know that we've got the first EU decision is one that came from the District Court of Hamburg in the Lion case, which was issued in September 2024. And basically there it was mentioned, although the conclusion from the court there was that the case had to be analyzed from an Article 3 perspective, it's that being the text and data mining exemption related to scientific research. However, as an kind of like an obiter dictum statement, the court mentioned that a reservation of rights expressed in natural language was likely to be considered machine readable, basically since in 2021 there were already technologies available which were able to detect opt-outs expressed in natural languages, which I think it's a very interesting approach as well. And that's basically most of it, I would say, in a nutshell.
And Chloe, what about the UK solution? You mentioned that there was some discussion also about the possible TDM exception. Is it similar as the one that we have in the EU?
Yes, I think yes, in short, the proposed solution was similar to the to the EU approach, excuse me. Just taking a quick step back, yeah, as Larissa mentioned, the UK at the moment has quite a restrictive regime where text and data mining, to the extent it's allowed, is only for non-commercial research. So as part of this government consultation and looking to reform, the government proposed several different ways forward for this. And one of them was to have a data mining exception, which allowed right holders to reserve their rights, underpinned by supporting measures on transparency. So, which would kind of lead you in the direction, as it were, of the DSM. So that you could have data mining for commercial purposes, so long as the AI company had lawful access to the relevant works. So, for example, through a subscription service, perhaps. The proposal has not made it into law, and it's unclear when or if it will ever come into law, actually, at this point. It was kind of, yes, there was a lot of sort of attempts by government to move it forward, and then back and forth. And the other UK lawyers listening will know that it's been quite the hokey cokey when people, which is obviously a very English phrase, but like when people couldn't decide quite what to do. And what we have just now in the last 10 days or so is something of a roadmap, at least for a way forward. So we have this Data Use and Access Act, which was passed on the 19th of June. And under this law, the government is required to deliver a report to Parliament on the use of copyright works in the development of AI systems. And the idea of this report is to really give more information on the various options that were for copyright reform, which the government consulted on, as well as anything new that they think about in over the next time. And that's going to be due, this report, 9 months after the Act passed into law. So, in effect, come back to us in 9 months' time, Mariana, and maybe we'll have some more answers, maybe some more ideas.
And maybe some more comment by Sir Elton John.
Undoubtedly, Elton and a bunch of others, I'm sure. Yeah.
And in Brazil, Larissa, you also mentioned that there was discussion around a TDM exception. How is it? How does it apply in Brazil?
Yeah, the Brazilian approach can be more conservative, as I mentioned, if we consider the current text of this bill of law, because, well, it states that the copyright can only be used if there is authorization, right? So that's point one. When we go to the TDM exception, same thing as Chloe, only for research purposes, for libraries, museums, non-commercial entities. Not even like a private company that tries to go with a non-commercial, that's not possible. But and it's different from the opt-out option of the EU, closer to what the UK have now. And just remember, we are still voting that TDM exception right now. We do not have it implemented. But this is the situation, and based on how the text is now, this is where we're leading. The courts can also be very protective of copyright, maybe with less elasticity concerning the fair use when they compare to the US, for example. So it's the TDM will be reliable only for these research institutes. The bill of law is being voted. There are a few consultations from members of all sides. There are some law experts assisting the debate, but this is the scenario we are expecting right now here in Brazil.
Okay, so this means that we have three different TDM exceptions approaches, which is interesting how the same legal mechanism can be applied in three different ways. We have the EU way, which is go ahead if it's for scientific purposes, go ahead if it's for commercial purposes, but there can be an opt-out. We have the Brazilian approach, which is more conservative. It's a go ahead for scientific purposes, but the rest, let's not do anything. And we have the UK approach of a let's wait and see and produce some more reports. Jim, we know that the TDM exception approach is mostly focused on the purposes of the use, if it's for scientific use, for commercial use. While in the US, you mentioned there's the fair use doctrine. Can you relate the concept of fair use with these purposes, or is fair use something completely different and purpose is not a part of the deciding process?
But it's somewhere in between, Mariana. So it's not whether the nature of the use, whether it's commercial or scientific, is not irrelevant, but it's also not dispositive. So you do look at, there have been fair use cases where entities have used content for commercial purposes, and it's still been found to be fair use. So there's no, per se restriction on it being fair use if it's commercial. Similarly, you could have a non-commercial use that could not be fair use. It could be infringing. So one of the four factors under fair use is the nature and purpose of the use. And what really is more important than whether it's for commercial or non-commercial use is really whether the use is what's referred to as transformative. So if you have expressive content and you copy it, and the purpose for copying it is really so others can enjoy the expression of the content, maybe in a slightly different form, that's going to less likely be a transformative use and less likely to be a fair use. On the other hand, if you use content for what's referred to as a transformative purpose, it's more likely to be fair use. So in the context of AI, the way the argument goes is that when you're training AI on content, largely what you're doing, if we look at text, for example, is you're not just copying the text. What you're doing is you're really understanding the relationships of words and how they appear. And so you're trying to abstract information about all the content that's being used. And that's really more of a functional purpose. And the purpose, the kind of the end purpose really matters. And what I mean by that is there was a decision a couple months ago in the U.S. involving a company called Ross. They were sued by Thomson Reuters. And in that case, Ross had copied the famous head notes from the Westlaw legal research platform. And they did it for purposes of creating a competitive legal research platform. And so there they copied the content not for a different purpose, but for the same purpose that it was that the content was used, from the material that it was copied from. And so in that case, there was a finding of no fair use. So, kind of to summarize that, it's very, very fact dependent in the US. All four factors are fact dependent. But on this issue of the nature of the use, you really have to look at, at a large extent, is it really transformative? And that's really the key focus for that part of the test.
We have had some calls about this, and we have discussed this for a bit now while preparing this webinar. And now, for the first time while I listen to you, I can find some resemblance with what Takafumi-san said a few minutes ago about the enjoyment of the artistic value of the original work, and that not being fair use and that not being covered by the Japanese exemption. So it's very interesting how turns out legislation and solutions do seem to come together in a way, and legislators and legal minds eventually think the same way around the world. So, Takafumi-san, we heard that in Japan there is this broad exemption clause allowing the use of third-party content to train AI models in order to promote development of science and of the society in general. As legislators in Japan were discussing this solution, what were the purposes that were the main object of concern in Japan? Was this an idea of just promoting development of the society and of science, or were there other concerns and purposes that were cared for by the legislator?
Yeah. So there is some concern from the media companies and also creators. So this our exemption clause was established in 2018. It was something before the generative AI. So after we are seeing generative AI, so creators and also media companies found so generative AI may be very big problem for their business. So after the so such emerging of generative AI, there are big discussion among media companies and creators and Japanese government. And so 2024, the Agency for Culture Affairs so published report about the type of the revision of interpretation of such exemption clause. And there are some concerns from creators, such as generative AI could learn from the works that creators spent time for creating, and also a large number of infringing work could be generated by artificial intelligence. In addition, generative AI could produce a large number of works similar to creators' style and voices that are not subjected to copyright, thereby straining creators' work. In fact, Ghibli case sparked discussion on social media. So after so such discussion about concerning generative AI, so interpretation was changed, and the considering this opinion, the agency changed its approach about protecting some exemption some protection about the commercial database, including copyright one. So this is a very important step for media companies and big creators for protecting their works from the running process of artificial intelligence. So this is what we saw related to concern from creators.
So it was not an absolutely liberal process. There were some cultural and artistic concerns and protection of copyright and of content and of media. It was also considered during the legislative process.
Yeah. So in Japan, there are not many judgment cases. So some change of interpretation can be done by such change of interpretation of the agency or ministry. Other than that, need to revise law or act itself. Yeah. So changing the interpretation is something faster than revising law and act.
Okay, thank you. And we also heard from Ricardo that in Spain there was also a legislative initiative providing a solution based on collective licenses. So licenses with collective management organizations. How was this supposed to work in Spain, Ricardo?
Great, thank you, Mariana. So I'm going to try to explain this as simple as possible because it's a bit complex and we don't have a lot of time. But basically, in November 2024, the Spanish government published a draft regulation, which basically aimed to create a mechanism of what is called collective licensing with extended effect, which is also based on a mechanism available through the 2019 DSM Directive, Article 12. And basically, this was made in order to kind of authorize or legitimize CMOs to be the ones to authorize use of works for AI training. The work, basically, in a summary, in a nutshell, the way this was going to work was basically that CMOs representing a group of rights holder, let's say, for instance, songwriters, could seek mandates from individual authors, so from individual songwriters who had opted out from the TDM exemption, okay? And through that mandate, the CMO would be asking to manage their right of reproduction for the purpose of AI training. And once that CMO had obtained a relevant number of those mandates from individual songwriters, it would request what would be called a representativeness certificate from the ministry. And if granted, that CMO would automatically be able to grant enforced licenses on behalf of all rights holders, regardless of whether or not they had actually received a specific mandate from the CMO. And for those right holders who hadn't given a mandate to the CMO, they would have the right to object to the management of their rights through said CMO. So this was going to work kind of like a double opt-out, you know, because first they had to opt out from the TDM exemption, and then if those authors who had opted out wanted to manage their rights themselves, they would actually have to do a second opt-out. It would be called right to object, but at the end of the day, it would be the same thing before the CMO, okay? I guess the reasoning behind this, well, it's not a guess, it was in the words of the draft regulation, was basically to enable individual right holders to jointly negotiate with AI developers to have a better negotiation strength, which could make sense in theory, since, I mean, AI training requires a huge amount of data, and in such context, if you think about it, one work or a relatively low number of works has little to no value by itself. So there could be a fear that negotiation of individual licenses will only be feasible for the relevant companies who hold the rights to a big number of content, right? Well, nevertheless, the draft regulation faced a huge opposition both from IP holders and from technology companies. So it was abandoned by the US Spanish government at the beginning of 2025. I think it was somewhere in February. So right now it's, I mean, they were supposed, or they're looking for additional solutions, but nothing has been published yet.
But that solution appears to kind of force small content developers to either opt out entirely or to just join the collective management organization, since they would have little negotiation power to actually enter into fair contracts, don't you think?
Yeah, that's a really fair statement. And I would say one of the things that surprised me the most is that, according to the news, also many IP holders were against this regulation. And that was probably this draft regulation, and that was probably the reason why it was not passed. So back in November, it seemed everyone seemed to think that it was going to be passed. But then when, the government decided to abandon it, I would say that it was kind of a surprise, because many technology companies, we know that they actually, opposed to it, which we can understand why, but it also received a lot of opposition from IP holders who didn't want to have their rights managed by CMOs, basically,
Yes, I totally agree. And Chloe, do you think that this would be a solution for the UK?
Well, I think it's one of those things where, like we've seen the EU experience, where it should, in a way, provide a kind of a way of bridging the gap between content creators and rights holders and AI developers. And we saw comments to that effect from the UK government report, which was broadly supportive of collective licensing. Talking, I think, in very similar times to the way that Ricardo's described, so that you've got, creators and performers able to license their rights to CMOs to given a mandate to license those works on a blanket basis, and that those collective licenses might be a really effective way, efficient way to license large numbers of works, which, as we know, you need large numbers of works for training AI. And that form of licensing might be more convenient as well for individual rights holders, rather than having to try to negotiate with other parties. And it's also convenient potentially for the AI developer. You can go to a collective licensing, to go to a CMO, and get that collective license and have a good degree of certainty as to what they're doing. But we, like the Spanish experience, would need new structures in place in order to make this work in the UK. So recently you've seen organizations like the Copyright Licensing Agency and other societies like the Authors Licensing and Collecting Society, who already have that kind of role, coming together to develop a generative AI license. So they're kind of moving ahead to try and come up with some kind of collective license, even in the absence of legislation mandating it, let's say. And so what the CLA, so the Copyright Licensing Agency, have said recently, that their aim in developing this generative AI license was to provide a scalable collective licensing solution that ensures remuneration for publishers and authors, and in particular those not in a position to negotiate direct licensing deals, and give AI developers of all sizes, so thinking about the new entrants to the market rather than just the Metas or the open AIs, the legal certainty needed to use a broad range of content and innovate and train new language models. So it sounds great. The new license is expected to be available for use in the third quarter this year, so quite soon, if not now, effectively, but sometime in the next few months. And we'll see. I think it's the sort of thing that to me, instinctively, it sounds like it could be a good approach, but we've already seen problems with it coming into force.
Okay, thank you. And what about the US, Jim? Do you think that this could somehow circumvent the fair use doctrine and just have a collective contractual solution that would solve all issues on AI training?
I don't think so. The Copyright Office issued a report back in May on some of these issues, training of AI, and one section of the report dealt with different licensing options. So voluntary direct licensing by individual entities, using collective groups to license for common groups like maybe book publishers or artists, images, etc. And the short of it is the Copyright Office didn't really endorse any type of mandatory licensing approach. It encouraged voluntary licensing where it made sense, and we're already seeing that. We've done a number of deals with big publishers who have large catalogs of content. They've been successful in licensing some of their content to some of the AI companies. The problem, one of the problems is that the long tail effect, right? For the individuals or publishers that have only a couple of books, the transactional cost of doing a license is on a one-off basis is pretty much prohibitive. And what there's a lot of problems with the collective licensing in that the nature of the work. I mean, not all books are the same, obviously, right? There's higher quality books, there's lower quality books, and trying to come up with, and the Copyright Office talks about this a little bit, is you're trying to come up with what would be a fair price, and how do you figure out like how you allocate that? It just would be a very difficult task. So, the short of it is, I don't think that'll be mandatory anytime in the near term in the U.S. The Copyright Office, kind of suggested that we see how the licensing market for AI training content evolves, and maybe down the road there'll be ways to figure out something, but I don't think it's going to happen anytime soon, if ever, in the U.S.
So again, we are talking about the difference of value among content, among works, and that's leading to the conclusion that collective licensing could not be feasible because not all copyright, not all work is worth the same.
That's one of the factors for sure.
Yeah. And what about Japan, Takafumi-san? Is this collective licensing model compatible with your legislation in Japan?
Yeah, I think so there is not such type of discussion in Japan for moving so that direction. So of course such so paid database can be protected by copyright acts, and also however there is big exemption clause. So mainly so contracts cannot rule out the application of exemption clause. So this is what is biggest factor in so Japanese practice. And however so in practice there are some such paid database, and also so some of the so AI developer would like to work friendly with the media companies or type of creators. So such type of developers entering into contract or with such type of the creators and medias. So this can be in some cases good for gathering high quality data and so new content from such creators. However, this is not main story. This is the situation in Japan.
So in that way, Japan is sort of aligned with the European continental law approach, which is law first, contract second.
Yes, at least in relation to copyright act. So this is the main perception.
Yes. And Larissa, what about Brazil? Is there any discussion about collective licensing in Brazil?
Not so deep conversations about it yet. I think it's not likely that CMOs would be created or involved in this discussion right now at this early point, or that it would be mandatory at all in Brazil. The most famous CMO we have here is the Central Office for Collection and Distribution of Music, which is known as ECAD, and it mainly controls the monetization over public performance of music very closely. But this system, as it is, it also has its flaws, especially regarding transparency and accountability from the associations to the owners. So it maybe could be used at some point when we are talking about works in large amounts, as you mentioned, but no discussion in the specific sense has been developed yet, since we are still trying to basically discuss, I think, the main issues through the law and yeah, no, I think CMOs here in the first look, it's not what the market is considering.
So it appears that Spain had a good idea for brainstorming, but in practice,
Who
maybe it
knows?
doesn't work.
Yeah, let's see how it goes. We do have CMOs for other aspects, and they might be used, but I think just right now we are discussing the basics, not there yet, you know.
Yes, I understand that, but it is indeed interesting to address possible solutions, because the state of the art these days is very unclear. We are drawing solutions from other legislation, from copyright legislation. So let's get into our last topic, last question for this webinar, which is, what other solutions can we think about? Is it just a matter of the law, hard law, or can we have soft law? What about policies, national policies, regional policies, international policies? Are there other solutions? Ricardo, what do you think?
Well, I guess looking back, I would say that maybe this should have been tackled on an international level, basically because the different legal landscapes kind of seem to create a forum shopping situation where basically AI developers are likely to choose those jurisdictions that have a more flexible approach towards AI training. In fact, the only case in Spain in Europe which so far has reached the European Union Court of Justice involving the TDM exemption, which is the request for a preliminary ruling in case C-250/25, which basically was published like a month ago, something like that, includes this discussion as one of the one of the arguments from the defendant is that training did not take place in Hungary, where it's basically the country where this request for a preliminary request is coming from. Well, nevertheless, given the very different approaches taken by each jurisdiction, right now it seems a bit too late to talk about international policies, but I still think that considering the effects of the different legal landscape, it's something worth exploring or at least discussing, you know?
Yes, perhaps one of the good topics for international policy to cover is the how opt-out could work, notably technical opt-outs, don't you think?
Yeah, that's a perfect example. I mean, yeah, that's there are still many smaller questions that can still be tackled at an international level, you know, and setting like at least higher standards. And it has been done many times. You've got the Rome Convention, you've got the Berne Convention. I mean, there are many conventions in intellectual property which have been, you know, passed on throughout the last decades, which, you know, could be helpful solutions here as well.
Yes, thank you. And what about you, Chloe? What do you think could be a good, adequate solution to address this topic?
Yeah, I mean, I think kind of like Ricardo's already said, it's hard, right? Because we've got such diversity in approach that we've already heard about, even from the 5 countries we have represented here, right? So a relatively permissive approach in different ways, perhaps in Japan and the US, compared to something more restrictive in the UK and Brazil, and then the EU trying to do something again. I think we do see at the moment, we see some countries being quite potentially quite artist or creative protective, and then others being more pro AI. So yes, you know, there's a real tension, and I think you mentioned the idea of opt-outs and how that can be developed. And I think that is one area where we see soft law as potentially a real way forward there, because it's kind of already happening, right? In the use of things like robots.txt, which certainly was not created with generative AI in mind, and so has its limitations and problems here, but you can see iterations working. And I think beyond that, for me, I do think there is a role for an international approach. I think it is probably, and I mean that in a kind of convention sense, but I suspect that is difficult. Let's say, I think given the diversity of approach that we have between countries and competing interests, I think that's going to be hard to progress. I mean, I'm just going to keep going on collective licensing. Let's give that a go. See if we can make that work. And for those countries where we don't, you know, where we don't have that kind of fair use approach, can we make another way in which it is relatively easy and accessible for AI developers and creatives to get some kind of access and some remuneration here?
Okay, thank you. And Jim, what do you think would be a good solution here? How can we solve this issue? Is the fair use doctrine the solution?
I frankly think it is. I think it's flexible. If you look at in the U.S., you know, copyright is constitutional, right? But there's a mistaken approach or understanding on the part of many that the primary goal of copyright in the U.S. is to protect the artists and to ensure that their rights are protected. That's actually the secondary approach. The primary purpose of copyright law in the U.S. is for the public to benefit from creators publishing their works. And so the public benefit is really the main argument, and there's been Supreme Court cases that have confirmed that. But with that, you still want to protect the artist's rights. And so I think you need some balancing. And just like as I mentioned earlier, like in the Ross case, you know, there was really no new benefit to the public. They were copying for purposes of something that, you know, kind of replicating something that already existed, and finding no fair use there is probably the right decision. I think if you're using content to create a new tool, the amount of infringement that actually occurs is very small, especially with the AI tools that use filters to make sure that, you know, you can't output any substantial content. So I think if you put, you know, relative, you know, safeguards and protections there, the primary use of these tools becomes a way to generate new content, not to copy existing content. And so to me, that's a public benefit. And, you know, it's hard. I get it's hard for the artists because as those tools proliferate, it's going to impact the market to a certain extent for existing works. But the fair use test takes into account the market harm. That's the fourth factor we really haven't talked about very much, but that is in some of these decisions, the most important factor. And so defining what the market is a very important part under the fair use test. And there's, I think, a difference of opinion. Even the two decisions that came out last week, the one court found that the use was very transformative. It was a transformative purpose, and didn't really focus much on the market, saying there really was no actual infringement, and so there was no impact on the actual works that were copied. Whereas the second decision criticized the first judge, saying that they didn't pay enough attention to the market harm. And so I think as we get more of these cases, we'll get probably a better balance of looking at the transformative purpose, aka public benefit, versus market harm, and how to really analyze that in an AI context. But I think that the last thing I'll say is that I really think that legislation would not be helpful here, because there's too many different scenarios. We're not going to have a per se rule on whether training AI on content is infringement or not, because there's too many variables. What's the ultimate use? How much do you use? Do you use safeguards? There's so many different factors. So the short answer is, I think fair use is actually a very good test. It's not easy. There's still this balancing of these four factors, but I think it provides the flexibility to take into account different scenarios.
But let me just tease you with a follow-up question.
Sure.
Is it not a good solution for us lawyers? Because it gives room to a lot of subjectiveness. There's a lot of interpretation. So ultimately, this gives room for lawyers discussing the cases in court, and it gives little certainty to the industry and to the people that are actually doing the work, or don't you agree?
Well, I mean, I don't disagree that is the effect of fair use being the test, right? There is subjectivity. It does create a lot of work for lawyers, does create some uncertainty, I think, for companies developing AI and to our artists or creators as far as what their rights are. So I agree with all that, but I think that because it has that flexibility, I think ultimately it'll if the judges apply the law correctly, you'll get fair results over time.
Okay. And what about you, Takafumi-san? You come from a country that is often associated with the pinnacle of technology. What do you think is a good solution for this issue?
Yes, yeah, so thank you. Yeah, so as I mentioned, in Japan, there are not many litigation cases related to new technology matters. So many cases are not resolved by court or ADR. Yeah, so new concerns from stakeholders should be taken into consideration in the process of the type of the legislation or changing interpretation of ministry or agencies. So this is the important step for Japanese laws and regulations. And so approach for the copyright and AI. So Japan has so very strong promotive approach about developing artificial intelligence. This is because not only our type of the technology country, but also we are in the very aging society, and so many of the labor force are retiring in these years. So there are very shortage of the labor force. So we need to immediately apply type of information technology more and more in order to ascertain very many type of service in society. So we need to promote information technology more than before.
And from what I understand, that promotion of information technology comes from actual guidelines for interpretation of existing legislation. That's how you promote change, by the interpretation and not by actually changing the legislation. Is that the case?
Yeah, so mainly, so we are making new regulations in relation to so change of interpretation in 2024 related to copyright and AI. This was done by the so changing interpretation by Agency for Culture. So mainly, so we set up promoted legislation, including artificial intelligence regulations. Or we took another approach than European approach, such AI Act. Yeah, so we are making regulations and laws, but in some cases, we need to take the such changing interpretation ways because of the type of the so very urgent type of the discussion matters.
To move faster.
Yeah.
Yes. And what about you, Larissa? What do you think could be a good solution to regulate this issue of use of third-party content by AI companies?
This is the $1 million question, right? What we're all trying to understand. Feeling and a bit considering my jurisdiction here as a civil law one for this answer, but I think it would be a mix of having the hard law for the basic concepts and legal certainty. We see that this in Brazil usually plays a key role, not like maybe going all the way to impair the evolution of the technology, but having a few basic concepts and also relying on case law, because courts play a key role here in Brazil, especially in new matters, and the fact approach, as mentioned by Jim, can be very helpful to guarantee this balance, specifically in a country that is looking for investment, which is kind of our case. But I think the mix of these two could be a guide. Of course, the judges' heads can be a surprise, we know, but we have to give it a go and count on everyone to collaborate. But in parallel, aside from hard law, having core decisions, I think massive or individual licensing would be they would be very important, especially considering the freedom to celebrate agreements and guarantee that parties can take care of their own rights. And we are kind of a step ahead in AI matters, discussing the bill of law and etc. But international cooperation is important, specifically since we are here looking to other jurisdictions. So the EU, based on even our bill of law, the UK, the US with the decisions, Japan with the exemption, but these to assess solutions and understand what we could fit in here. But we talked about this all the time when we were discussing, right? This webinar. This is something that is not limited to your territory. So we are talking about technology, and the same AI company that is working in the US, is working in Europe, is working in Brazil, and they are also trying to how to put a business that is going to work out on all of these places. So maybe international support would be one of the tools. I don't think there is one thing that could happen here. I think we can try to assess everything we can. So I don't know, maybe just use the law in a way that is not going to impair the technology, but also having a little bit of restrictions, or at least trying to find the middle ground. It's hard. Maybe it's an answer with it's an I don't know, but yeah, these aspects could for sure assist on the discussion.
Yeah, I think it's interesting, although not exactly surprising that the only person who doesn't think that hard law is a solution is Jim from the US. Everyone else is very much favorable to some law, as well as international conventions, treaties, or some sort of international policy, so that we are all aligned. But indeed, I do agree with most of you in saying that there is not only one legal solution to this, and I don't think we will know what is indeed the legal solution for some time. But maybe that's a good topic for another webinar sometime in the future. And with this, we end our webinar. I don't know if anyone has any questions that you would like to make to any of the speakers here. If you do, okay, I see that Dove has one question. Go ahead.
First of all, thanks. It's Dove Scherzer from New York. I think it's been terrific. Thanks all too for doing this. I just wanted to pick up on a couple of things that Jim said. I do think he's exactly right. I think, as we all know, the United States is pretty allergic to global, national regulation of all kinds. As you all know, we've been speaking for decades about privacy law there being no national law, that it's just a patchwork of various state laws. And so go figure it out. While the GDPR and others, Europe tries to figure it out, and we're influenced by it, but we still, decades later, don't have that. I don't see it happening here, especially given the pace of the technology. In a twist on AI, just a couple of things I want to mention is that in the bill that is currently being negotiated in the U.S. Senate as we speak, there had been a requirement, a provision that there would be literally a 10-year moratorium on states enacting any AI legislation. So even something like CCPA would be covered potentially by something like that. Some of the states who did take advantage of that to try to push along some privacy legislation. That seems to be pulling back slightly in the current version, but not meaningfully, in the sense that it's going to be, or they're suggesting that it be, oh yeah, you can have regulation, but if you enforce it, we're going to take away funding from you. Okay, federal funding. So this is all a wonderful state of affairs from that perspective. The only other point I'd want to make is that just last week, there was a fair use case ruling in the Anthropic case, which essentially held that it was a fair use for Anthropic to make the use of thousands of books, and it was under fair use grounds. That the argument was that it's being used for another purpose. We have to all the things Jim was saying, and that's what we do. It's always existing laws in the United States, and then it gets applied to new technologies, and then we see where it goes.
Before I refer to Jim to comment, I just want to say one thing. The US has a big allergic reaction to legislation, as you mentioned, but it also has big pharma companies that can produce antihistamines, so I don't understand the issue. Okay, so Jim, what do you think? Do you want to comment what Dove mentioned?
I agree with the comment as well. I mean, I think that the on the particular issue of training, I don't think we'll get legislation, but there is a lot of pending legislation on a lot of different aspects of AI, more like the harmful uses and things like that, and the kind of the proposed moratorium on state enforcement of laws is really interesting. If it actually gets implemented, I think the advantage of that is obviously, we've seen having a patchwork of state laws makes it very difficult for companies to comply with all the laws if you're operating in more than one state, which most people do. And so, if we had a coherent federal policy and reasonable legislation where states could maybe have input on it. And there was a consensus, but I just don't see that those laws happening anytime soon, just the pace at which laws get passed in the US, which is not very rapid, as many people know. And particularly in this context where there's such, on many of these topics like training, there's such competing concerns. I think it's going to be hard to get laws passed specifically on these topics. On some of the broader topics like, safety and things that are, harmful to consumers, I think there's more consensus around that. And I think, if there's, federal law that gets passed, it'll be more in those areas as opposed to, what constitutes fair use on training.
Okay, thank you. And do we have any more questions from the audience? We are a bit over time. This was supposed to take 1 hour. It's going on 1 hour and 17 minutes. But if Margaret allows it, maybe we have time for an additional question. No?
Certainly. If there are any other questions, I don't see any in the chat. If you don't want to be on camera, you can always type it in there.
It appears that we don't have any other questions, so we will end this webinar here with a big show of appreciation to Margaret for taking care of all of the admin issues surrounding this webinar. Also, thank you to Jeremy Morton for the initiative and for setting up this group. Thank you to my fellow speakers here, and let's maybe talk again soon and pick up this topic in the future, which is certainly not closed, not established, and there's still a lot to be debated around this.
Big thank you to you, Mariana, for leading us through it.
Yeah,
Thank you.
very much,
Yep.
Mariana.
Great job moderating.
Thank you.